Welcome to the second of our panels today afternoon, this one on remedies, injunction, and exclusion. We have a very distinguished set of panelists to discuss the topic with us here today. Our first speaker is John Golden, who is a professor of law at the University of Texas, Austin School of Law. He'll be followed by Mark Lemley, professor of law at Stanford Law School, followed by Scott Kieff, who is a commissioner at the US ITC, one of our very distinguished graduates, I'm glad to add, and also a professor of law at the George Washington University School of Law. And our fourth speaker is Matt Levy, who is the patent counsel for the CCIA. We've decided to make this panel a little bit more participatory and discussion-based. So each of our panelists is going to speak for about 5 or 6 minutes each, and then we'll go straight into a discussion amongst them, and then questions from the audience. So without further ado, over to John.
Okay. So this panel is on injunctions, and I'll just give some introductory remarks. I assume, given the shows of hands we've seen earlier, that people in this room are fairly sophisticated in the patent context, probably know a lot of what's been going on already. So you may have heard about most of what I'm going to mention, but just to make sure people are up to speed, I'll give a quick overview. So as has already been mentioned, we had a case decided by the Supreme Court in 2006 called eBay versus Merck Exchange, where the Supreme Court said that the Federal Circuit had erred in adopting a kind of general rule that injunctions would issue, permanent injunctions would issue at the end of patent cases when the patent holder had established infringement and had successfully defended at least one patent claim against charges of invalidity and or unenforceability. The Supreme Court said that instead, courts needed to apply a four-factor test, which they described as a traditional four-factor test for permanent injunctions. Namely, the movement would need to show irreparable injury if the injunction did not issue. In fact, they seem to say the irreparable injury had already occurred. They had a past tense problem there that's sometimes been ignored by the courts. But in any case, the movement has to show irreparable injury of some kind, has to show inadequacy of legal damages, a redundant factor, but it helps get to the magic number of 4, which matches the preliminary injunction test. The movement has to show a favorable balance of hardships, and then an interesting shift in the wording. The movement has to show that the public interest would not be disserved by the injunction. Well, there have been debates about how to understand and apply that four-factor test. A number of courts in the patent context and outside the patent context, including the Federal Circuit in the patent context, have decided that this formulation by the Supreme Court means that prior presumptions of irreparable injury for, say, a continuing course of patent infringement no longer apply. And we've also seen the Federal Circuit now developing and debating with some interchange with a particular district court the meaning of a causal nexus requirement for irreparable injury that's been in the Apple-Samsung case, where there's now an analysis that can need to be done of whether the irreparable injury that's been alleged is traceable to the infringing aspects of a product or process and isn't simply incidental to those. Okay. Further, there has been, as was suggested by the last panel, questions about when injunctions should be available in situations where there have been FRAND commitments by parties, something that we can expect to be continue to be debated until at least the Federal Circuit or perhaps the Supreme Court weighs in on that definitively. The practical meaning of some of these changes are that injunctions don't issue in all cases. They're tending to issue now, I think according to some studies, in about 75% of cases. So still issuing most of the time, generally not issuing if there's a non-practicing entity asserting the patents, at least if it's not a non-practicing entity that's an Australian research foundation. What this means in practice is that damages determinations have become, at least one practical effect is that damages awards have become more important, both in terms of determining past damages and in determining the so-called ongoing royalties or running damages in the future that might be awarded in lieu of an injunction. And there might be some discussion here or questions about how those ongoing royalties should be determined. I've done some empirical work on injunctions that looks in another direction. There's been all this debate over when injunctions should issue. I've done an empirical study that's looked at the nature of the injunctions that issue, the injunction scope, how injunctions are drafted. And this is something that I think remains an area that should get more attention, that practitioners should think about, and district court judges should think about more as they're trying to determine whether injunction should issue. Usually the question of whether an injunction should issue is dealt with in the abstract without considering whether some of the potential problems with injunctions could be dealt with by tailoring the injunctions in one way or another. How did I get into looking at this problem? It was actually because of a particular case, the Tebow v. EchoStar case, where in that case the district court judge had awarded an injunction which didn't just say, as would be typically the case, don't continue to make the adjudged infringing products or processes. Instead said, well, you need to disable the DVR functionality of your set-top boxes. Okay, so it's a disablement injunction which went beyond simply saying don't infringe, might be viewed as clearer, however, than a kind of do not infringe injunction, because you didn't have to determine whether a new product or process was merely colorably different from something that had come before. So there are questions about the legitimacy of such an order, which the Federal Circuit didn't address in the Tebow EchoStar case. Also, I was wondering how often these sorts of things issue. Do district courts issue these things more frequently? Well, in doing that, I did find that district court judges, though they don't do it most of the time, do issue various types of specially tailored injunctions. Some, like this disablement order, sometimes it's a destruction of devices order. Other orders where they hit correlated activities like displaying or advertising a kind of infringing product. Others where they almost draft a new kind of pseudo-claim for the injunction, which might help if it's well drafted with some of the notice problems that were being indicated in the first panel for today. Another type of injunction can be what I call a moderated injunction, where they actually carve out certain type of activities, create a sort of safe harbor for patentees. So there are a lot of opportunities for tailoring injunction scope, potentially to mitigate some of the concerns with injunctions. What I also found, however, was that the majority of injunctions that were issued by district courts in 2010, at least of the 143 injunctions I found, the majority were actually technically wrongly drafted according to Federal Circuit law, because they included just general do not infringe this patent or this patent claim language, whereas the Federal Circuit has said that sort of injunction is contrary to the specificity requirements under Federal Rule of Procedure 65. So this suggested to me that this is an area where we should put more attention, not only to making sure the drafting of injunctions is technically correct, but also thinking about how they might be structured and shaped in various ways. Thanks.
Thanks, John. Mark?
I'm going to stand. So I want to talk a little bit about eBay and where it's left us, and then think about some of the what I view as the sort of frontier issues that we're facing right now in injunctive relief. I start from the proposition that I think Laura Sheridan actually quite well articulated this morning. Part of the problem in the pre-eBay world was there were a lot of patents out there of dubious and uncertain quality. Some of those patents were in the hands of trolls, some of them were not in the hands of trolls, and most patent suits today are in complex multi-component industries. When you combine those facts with the fact that, as she pointed out, it's pretty easy to file a lawsuit and it's pretty hard to dismiss even the weak case early, what you saw in the pre-eBay world was a world in which I could credibly take almost any patent, no matter how bad it was, file a lawsuit in a jurisdiction where I'm likely not to get summary judgment granted against me, and say to an Intel or some other large component device maker, well, you know what, I got a patent on this little component. Maybe you think it's no good. Maybe you think you can invalidate it. Maybe you think it's easy to design around in the next generation of your products. But if I win, I'm going to be entitled to an injunction that will shut down your semiconductor product until you can turn around and design an entire new generation. And people faced with this threat, even if they thought the objective chance of the threat was 5 or 10%, it's hard to come up with a story of the legal system that says the chance of a bad outcome is ever less than 5 or 10%. You never know when you're in front of a judge or a jury, would pay a correspondingly large amount of money to avoid having their microprocessor shut down or their core product sold and so forth. And the result was a quite substantial holdup problem, some of which you saw percolate its way into actual reported court decisions, but the majority of which was in the form of often quite large settlements behind the scenes to avoid this problem. And by this standard, I think eBay has been an unqualified success. And I say it's been an unqualified success because it has made this problem better. It certainly has not made it go away, but it has made the problem better. It's reduced the amount of money being paid without much interfering with injunctions for those who actually need them, right? Without much interfering for injunctions in the practicing entity cases, in the pharmaceutical cases, and so forth. So a study Colleen Chen and I did last year finds that 77% of practicing entities still get injunctions in the post-eBay world. Interestingly, courts also distinguish between types of non-practicing entities in their injunctive relief. Non-practicing entities who are universities or individuals actually had higher injunctive relief win rates when they won their cases than the practicing entities. Those were in the up around 90%. The people who actually had a really hard time getting injunctions were the PAEs, right? The folks who are in the business of asserting patents for a living. Only 7% of the contested PAE cases led to injunctive relief. Now, I actually think that the way the court has started to break this out distinguishes pretty logically between two sets of cases. If I'm suing my competitor, particularly in an industry like pharmaceuticals where I am likely a monopolist in the absence of a generic entrant who might take away that monopoly, what I stand to lose by infringement is more money than the defendant stands to gain by infringing. Right? Monopoly pharmaceutical companies lose more money in the case of infringement than generics make by competing with them because the generics sell at a lower price. What that means is that patent damages are not terribly well suited to compensate the patentees in those cases. At a minimum, you're going to have to hope the generics got a bunch of revenue sources from something other than the infringement that we could then pay to compensate the patentee with a lost profit story. By contrast, when the damages theory is a reasonable royalty theory, not a lost profits theory, which is generally true in non-practicing entity cases, the reverse is often true. That is, the loss to the patentee from an act of infringement, which is the lost licensing revenue, is often, in fact, I think by definition almost always should be, less than the gain to the defendant by infringing. Because the idea of a reasonable royalty is we take a surplus created by the defendant's action and we split it as a reasonable licensor and a reasonable licensee would. We negotiate for part of that surplus to go to the patentee. And so this actually, I think, maps pretty well to eBay because it's what eBay says is in the circumstances where your practicing entity is suing a competitor, where they're likely to have price erosion, to have things, their price taken away from them in a way that the defendant couldn't obviously compensate for, you're likely to get an injunction. Where you're in a world in which you're only going to have a reasonable royalty negotiation and you should be splitting the surplus, an injunction's not likely to happen. So, with that framework and with due acknowledgement to John's point that the eBay court was doing something which was only partially historically accurate, I think they've done something which turns out to be a pretty good policy because it's managed to distinguish between these two types of cases. All right, so 4 frontiers that I think are presenting more challenging issues for us. First is the International Trade Commission. We will hear from Scott, I suspect, about this in just a moment. But the ITC offers a potential end run around eBay because the ITC is not subject to the eBay regime. And we've seen both trolls, which at least in 2011 made up 50% of the assertions in the ITC, and those who have already committed to license their patents on reasonable and non-discriminatory terms head to the ITC because they think that while I can't get an injunction in court under eBay, maybe I can still get an injunction in the ITC or an exclusion order. The White House has stepped in a recent case to try to limit that in some circumstances. I think probably correctly. But the ITC statute also has organic power that allows them to consider whether or not an exclusion order is always appropriate. Second issue we've seen develop in the Federal Circuit in the last 2 years is the idea that independent of the four-factor test, or maybe as part of the four-factor test in eBay, there's some kind of a nexus requirement between the product that is covered by the patent and the purchase decision made by the defendant's consumers. So in the Apple versus Samsung preliminary injunction case, the court said, yeah, you've got a patent on slide to unlock, Apple, but nobody buys phones because they have slide to unlock feature, and so even though you're a competitor, you would otherwise be entitled to injunctive relief under the eBay standard, you fail because you can't show a nexus between the infringement and any actual harm to your marketplace. No one's buying Samsung phones instead of Apple phones because of this. That's an interesting problem. The court started to back off a little bit from that nexus requirement in its next Apple-Samsung case, one decided just in October. And I think one of the difficulties is that if you try to think about the market structure, it's not clear what kind of nexus we would really want to have. If you required everybody to buy the product because of the patented feature, you'd never be granting an injunction. If the answer was, is there one person of the 400 million people who've bought smartphones who actually really love slide to unlock and was otherwise on the fence as to which phone to buy, well, you might be able to find such a person. So the court seems, in its more recent opinion, to be thinking of this as a kind of a de minimis threshold to overcome. You got to show that your patent is at least important enough to the product that there's some number of people who are going to be affected by it. The third issue is, and maybe I'll stop with this one, is the issue that was at least raised by the panel that just preceded us, and that's the Frand injunction question. There is, I think, properly a balance between what Richard Epstein called hold-up and reverse hold-up that you can achieve in these cases by, on the one hand, not allowing someone to make a contractual commitment to license their patents and then go back on that contractual commitment, just refusing to license or suing or selling the patent to someone who did, but on the other hand, preserving for those patent owners the ability to seek injunctive relief against people who are not, in fact, willing to pay a reasonable royalty in licensing. And what we've seen in the reasonable and non-discriminatory licensing cases is some pretty extreme positions on both sides, some of whom basically say, Frand means nothing, I can do whatever I want, including sue you for patent infringement, but some of whom essentially say, you can never get an injunction against me regardless of whether I'm willing to agree to pay a royalty that a court later determines to be reasonable. I think there's a middle ground to be walked there that suggests that injunctions are at least potentially appropriate as a threat point, if but only if contractual negotiations fail. So with that, let me turn over to Scott.
Great.
So first of all, just to say that it's really wonderful to be here back at Penn, my alma mater. I'm even wearing a red and a blue tie, although I happen not to have bought it at the bookstore. It's because I'm in this new role, though, I'm on leave from my academic post, working full-time in the government, so I hope you'll permit me to just point out that the views I offer today are my own views, and I hope you will not attribute them to my current employer or colleagues or former employer or colleagues, plural. So, as we think about, then, these ideas, they are, I'll try today to talk about sets of ideas that are already out in print so that people can read more about them if they like. The paper that Richard mentioned earlier that we co-authored at the Federal Trade Commission, and paper co-authored with Ann Lane Farrar that is just coming out on patent remedies. So the idea here is to take seriously the lovely, helpful set of ideas that were waiting for me on my desk in my new employer when I arrived this fall, which is the White House's Office of U.S. Trade Representative, instructing the world, including the ITC and others, to think about holdup in the patent context. And so that letter to my current chairman talks about there being multiple types of holdup. So it's just worth asking ourselves, what are they? So let's just think about that. People talk about patent holdup. That, I think, is a term that gets thrown around a lot. I'm not sure exactly what it means. I think if I hear it right, it sounds like it means something like the following. The idea that an entity that wants to use a patented technology might find itself victim to what economists call holdup. Okay. Well, then what do economists call holdup? Holdup is not, hey, wait a minute. Holdup is not, I don't like what you're doing. Holdup is not, I wish you had told me that you don't like what I'm doing sooner. Holdup is something pretty special. It's some significant investment that is reasonable at the time it's made and in the degree that it is made. Some surprise after making that investment, and some opportunism by somebody else who wants to take advantage of your having made that significant, reasonable investment, and you're now being surprised. So in the patent context, I think we should be very sensitive to what people in the IP field call clearance searching. The cost of figuring out. This morning we heard about how hard it is to figure out what's owned in the patent space, and it really is pretty amazing. You can walk out on a typical street in a typical city, and there will just be all these automobiles sitting around on the street. And we could all spend a lot of time figuring out the countless ways in which the ownership rights could be arranged in those automobiles. Maybe a married couple owns them. Maybe a single person owns them. Maybe 4 college roommates share ownership. Maybe there's a loan. There are so many possible arrangements. The information costs are extraordinary. But it turns out that here's the only thing you really need to know in most cases about those cars. They're not yours. Your search costs are quite low. The one your key opens, you can spend as much time thinking about as you like. And the other ones, you're welcome to think about, but you don't have to think about. Now, sure, cars are tangible. You might accidentally find that you're infringing a patent. So maybe the socially optimal search costs for patent infringement are something close to low. Close to low. Maybe they're a little bit above zero. I mean, after all, www.uspto.gov provides that information for free if you want it. But one of the things we seem to hear a lot in today's discussion is, all these lawsuits that are happening. And here's the thing, I can imagine really not knowing what's going on. Who is giving me a hard time? Who could give me a hard time? And if I'm fretting about those things, you might have sympathy for me. But if I'm in a lawsuit with somebody, you should not have sympathy if I can't figure out who's making my life difficult, because it's the guy on the other side of the V. We know who that is. He's announced himself, and I can talk to him. So I don't know exactly what's going on in the patent holdup context. We'll talk more about that, I think, during the discussion. But we should keep track of clearance costs done at some level, above a level that is just not, above a level that is significantly socially suboptimal. What do I mean by that? Like zero, or the Supreme Court's global tech cases discussion in the inducement standard, willful blindness. In other words, what about those infringers who are willfully blind? That's probably not good faith clearance searching. So we could take seriously that. We could take seriously sunk costs that are reasonable, that are asset specific, in other words, that can't be redeployed in some other way, and then opportunism by the patentee to take advantage of that. But we should be mindful, as the USTR instructed, of reverse holdup, other forms of holdup, where patentees and the people who contract with patentees get strung along by opportunistic infringers who hold out, who wait until some entity, a court or an agency, intervenes. How hard it is to set a standard then if nobody wants to agree on a standard while everybody waits to see who the last person who gets the best decision from the agency or the court gets it. And of course, there's the concern that if this other person gets, if infringers in effect get preferred treatment, why are people going to bother to talk to each other on the front end? So we have a lot of different types of holdup, and we have to really balance them against each other, and we can talk more about that during the discussion about how to do that. Thanks.
Thanks, Scott. Matt?
Well, let's see, is this? I
Yep.
can't. All right. Well, I'm going to talk sitting down because John spoke sitting down, and I don't want him to be the only one. I actually want to follow up on something that Mark talked about, and that's this idea of the fact that we have so many accused products now with components, and the patents that are being applied to them tend to be for smaller and smaller features. You know, there was a tendency, I think, early on in the patent world for patents to be for an entire good, the entire machine or the entire wheelbarrow or whatever the entire thing was that was being sold. And there's a real disadvantage to patenting like that, especially now. If you list all of the features in one claim, it becomes much easier to design around that patent, right? Because if we have a complex device with maybe 50 features, I can build a device with 49 and I don't infringe. So there's been a tendency now to try and patent the other way, bottom up, and patent as many of the individual features as possible. That's certainly more effective protection for competitors. It's also more effective for PAEs, but there's sort of a mental problem that we have with this. We still think often about these smaller patents as sort of proxies for the entire good. So when Apple sues Samsung, Apple, as I think they publicly said, feels that Samsung ripped them off, or Android is a rip-off, the whole product. But that's not what they're suing on. They're suing on patents for much smaller features, whether it's the rectangular shape or the slide to unlock or the feature when you, some other feature of the phone. We have to be careful when we're constructing our remedies, or at least thinking about it. How much protection do we want to give? Do we want to treat this circumstance as really just a proxy for the larger war, which is a larger product, and of course the patent owner who makes a product is going to be saying that? Or do we want to do what Mark was talking about, find the nexus requirement, as the Federal Circuit is trying to? Do we look at these individual, these much smaller pieces and say, well, how much is responsible for the phone? Of course, that's an exercise. Well, I'm glad I'm not a judge, is all I'll say. I don't have to do it. It's certainly not easy. But the other, I think that this actually explains why the ITC has become so popular. The ITC, of course, has no choice. Generally, it issues an exclusion order or it doesn't, or cease and desist order as well. It doesn't have partial remedies. So if we have a small patent that covers only a small piece of the product, we can still exclude the entire good. The ITC is not able to be granular in the way that we'd like a court to be. And even district courts still have trouble. They can issue an injunction that can be somewhat creative, as I think John was talking about. But still, generally speaking, it's all or nothing. So I don't really have so much of an answer. But my experience, I've actually been, well, the last 3 months I've been lobbying on the Hill largely, working on the bill that Professor Epstein was talking about. So I would like to say one thing, which is we won. It's a good bill. It's not bad. That was completely inappropriate, but it's fine. Of course it's not. That's why I want to revel in the goodness while I still can. Of course, now I lost my train of thought. I was talking about the ITC. So, we have. Before that, I was a litigator, and so I've seen the problem here. We have the threat of the injunction. We have which tends to raise settlement values. If we lower the standard for injunctions, then we may find defendants or infringers who are much more willing to infringe. It's a delicate balance, and it's certainly not. We're going through this now. I expect that the ITC will probably get sucked into this debate, whether they want to or not. But I really just want to put those things out there. I'm looking forward to the discussion. As a practitioner, of course, I have no solutions. I always just say, well, it depends on the circumstances.
Great. Thank you, Matt. So why don't I turn it over to the panelists to see if they want to respond to each other's comments, and before we open it up to the audience.
Let me say one thing. I appreciate Scott's comments, and I think he's on the right issue here, right? Which is it actually feasible for me to figure out ex ante who's got patents I need rights from? If it is, I ought to do so, and if I'm willfully avoiding doing so, then we've got a problem with that. But I think it's worth remembering that in the information technology industries, where we're now seeing a majority of patent litigation, that system, that idea is broken, and I think probably broken beyond repair. It is almost never the case in the IT industries that defendants copy from patentees. Even the allegations that the defendants actually copied this technology from me occupy maybe 2% of the cases. Chris Kotropi and I did a study on this a few years back. And the reasons for that are myriad. I think part of the answer is it's a fast-moving industry, and the Patent Office is not a fast-moving agency. So the idea that you're going to copy a technology that you got out of a patent means you're almost by definition 4 years behind your competitors. But more generally, when you combine that with the problems Mike Moyer talked about in identifying patents, the result is that in the information technology space, there's essentially no such thing as clearance searching.
Yeah, but let me just ask, because otherwise we might, I might lose track of what we're focused on. I mean, because I'm trying to figure out what to do, and I think we should all try to figure out what to do. We should take seriously the concerns. So in a setting where there are actual disputes going, there's no uncertainty about who you need to negotiate with. In a setting in which people are getting together regularly at standards bodies or other bodies, there is no difficulty finding each other and talking to each other. And in settings where even whether an entity is so-called practicing or not, that entity happens to have a very, very large portfolio of patents, then it seems the thing to talk about, the number to count, is not the number of patents you need to license, but the number of entities you need to talk to. And if that number of entities is a small number, even if you have to talk about thousands of component patents and even more thousands of IP rights, if you're only talking to 3 people, it's still 3 people.
And I think in the standard setting organization context, that argument has some purchase, right? And it's the parties do know about each other. They ought to negotiate. And I think that's exactly what the FRAND commitment is about. They have negotiated, at least in part. Now, part of that negotiation is an agreement to negotiate the rest of it later. But that, I think, ought to be a matter for contract law, how that's interpreted, right? And I agree. In the once you're outside the standard setting organization world, it's not the case that we're talking about 3 possible people who might show up and sue me, nor 30, nor even probably 300, but more like 3,000. And part of that problem is there are an awful lot of patents out there, right? So the chief legal officer at Google estimated a couple years ago that there might be 250,000 patents relevant to the smartphone.
But I'm sorry, we're getting off again. Let's go back to what you've just talked about. So I'm comfortable talking about this because this was at the commission before I arrived. I know only the public record. But the public record in the Apple-Samsung case is a 130-page opinion, of which there are something like 40 pages discussing whether there is any evidence of standard essentiality and FRAND commitment. Now, maybe the human beings who wrote those 20 or 40 or 50 pages, depending on how you count, were filibustering, but maybe they did a totally reasonable search, and maybe they wrote a totally reasonable set of 40 pages. Now, if you think they got it wrong, then I guess there should be some specific error that we could point to, and we might ask, did they get wrong whether there was evidence of a FRAND commitment? Did they get wrong whether there was standard essentiality? Maybe they did. Maybe they didn't, though. Maybe we also could ask, who bears the burden of showing up with the evidence necessary for them to decide the things you're eliding past as we move on to another discussion? If somebody thinks a patent is essential, maybe there should be some proof of that. And if somebody fails to prove that, and if 6 commissioners and a set of staff and administrative law judges and hundreds of pages of effort and testimony are examined, and no one finds it, okay, maybe we should fund them more, maybe they should look harder. But if there's no evidence, there's no evidence.
Mark, before I let you jump in, can I get Matt and John into the conversation if they wanted to?
Yeah, I guess, I think you may be talking past each other, but I have some familiarity with the Apple-Samsung case, so let me talk about that. The one interesting question that I think was brought out that I want to make sure we get at is whether or not it's enough for, say, Samsung or whoever the patent owner is to say that something is standard essential, or does there need to be an inquiry, as the Commission felt there was, to actually decide whether, as a factual matter, this patent is essential to the standard. Does it matter? Is Samsung wrong? They say it is when they're negotiating. Maybe they're wrong. Should that matter? There are certainly some who feel that, and I think there was a lot of public comment, that people felt that it was enough for them to say it, and it should be treated as standard essential because that was the leverage that they were using when they were negotiating, and it was a waste of time for the Commission to actually determine to make a determination of, I guess, infringement of the standard by the patent, or infringement of the patent by the standard.
John?
Okay, yeah, I wanted to just throw a few thoughts on the clearance question. I do think this is a very important problem to which I don't know the answer in terms of what are the best practices for patent clearance. We do have a difficult issue, as Scott suggested. We would like to make sure there are incentives for those who might be infringers to do proper patent clearance in advance. On the other hand, I think the problems with patent clearance are very hard, and it goes back to some of the points that Michael Moore was making earlier today. Having been a practitioner and trying to write sort of patent clearance type opinions, or at least to do an analysis, where often it turned into a not so clear analysis, it's difficult to understand the scope of a lot of these patents. So you end up, there's a chance a court could construe this in a way so that you're going to be found to be within the scope of the patent. Validity is often questionable, legitimately questionable, but again, a judge or jury could end up upholding the validity of this patent. And then, as we've seen discussed earlier today, the valuation problems can be huge. And even after you're in a situation like that which Scott has suggested, where you know the party on the other side, if you disagree about the percentage chances of validity or of infringement, and then even if you agree on those, if you disagree massively on valuation, which is another huge problem, another great source of uncertainty, where we see parties often come in with valuations which differ by a factor of 100 or more, then it's quite understandable that you have a dispute going forward. And I think it's a really difficult question for our system as to how do you balance these, and what is the kind of level of patent clearance activity we need to try to make sure we encourage.
So I want to let Mark and then Scott and then back to Matt, and then we'll open it up.
Well, so I guess I would say a couple things. So Scott understandably wants to talk about the FRAND issues. I actually was trying very hard to avoid getting into the FRAND issues. And I think one of the problems at the ITC is that the ITC finds itself in a difficult position with respect to these issues because the only remedy it's got is an exclusion order. Right? So if we think of this as was suggested in the prior panel as really a contract dispute, we've signed FRAND's a contract, and so we've got to debate over what's a reasonable royalty. We've got to debate over what the non-discriminatory provisions mean, and we ought to resolve as a matter of contract law. The ITC is just not well suited to do that, right? Because they can either say, keep the products out of the country altogether, or they can say, well, we found infringement, but we found no remedy. And so I understand the difficulty with that, and I think it's a problem with the way we've structured the right. But I do think it is worth remembering that the right way to think about a FRAND obligation is as a contract, and that what we really want to do at the end of the day is to determine that contract issue. The only other point I want to make is not on the FRAND issue, but goes to this clearance issue. Scott's right that it's not the number of patents we should care about, it's the number of parties. But there are a lot of parties out there, and you have no idea who they are. Part of the reason you have no idea who they are because their patent might not have issued yet. Part of the reason is because it might have been transferred and that transfer not recorded. Part of the reason is there are just lots and lots of different patentees out there. But part of the reason has to do with the patent reform issues around real party and interest, which is patent ownership names might not actually mean anything to you. It might be that there are a few people who secretly have a bunch of the patents that are relevant to your life in the non-practicing entity world. But if they've split those patents into 500 or 1,000 different shell companies so that they can approach you one at a time and get a payment and then approach you again next week with another one, it's going to be awfully difficult to engage in that negotiation, at least unless we get some information and some transparency as to what's going on.
And I guess since time is limited, let me just give some quick notice a few things that are puzzling for me. If we don't understand if the kind of prototypical, famous, infamous cases of lack of patent notice in the software space are cases like TiVo and i4i and RIM and eBay, let's at least notice, pun on words, that these are all cases that went very, very far because every judicial officer involved in the cases came to the exact same agreement. About, number one, every single one of patent law's disclosure requirements had in fact been satisfied. Written description, enablement, best mode, and definiteness. So whatever I don't know what it means, in patent law language, the 4 ways patent law tests whether you know what you mean were all met by every court that looked at every one of those patents. And it turns out that not only was maybe those standards are the wrong standards. Maybe Mike's asking the right question and others. Maybe we should shift those standards. But what about the subjective question? We're here thinking about this innocent infringer who had no idea they were infringing. And yet in those prototypical cases that everyone points to, they were willfulness cases. You can't willfully do what you don't know. These are cases where the infringers knew exactly what they were doing. That's why they were willfulness cases. Now again, maybe the evidence was bad. Maybe they shouldn't have been willfulness cases. Maybe we have our willfulness standard wrong. Maybe we could adjust that further. Totally willing to have those conversations. But when we have these conversations, we should at least keep track of what we're talking about. These are, if there is a notice failure problem, how have we failed it when we specifically intend to do something? It just totally confuses me. So let's end with the last prototypical case that everyone talks about, the horrible case of Research in Motion, which settled for over $600 million, and that sounds like a total shakedown. And for those of you still in the private sector, That's a lot of money, right? It takes you like a week and a half to make that kind of money. It's big bucks. I get it. But it's worth noticing $620 million. Everybody should keep track of this case. The public estimate of the case was $1 billion with a B, which is about 2 times what the case actually settled for. The infringer, Research in Motion, was a publicly traded company in Canada and had told its shareholders, as every publicly traded company does, please keep investing in me. I've set aside a reserve fund to pay out this case, and I'll still be profitable when I pay the reasonable damages in this case. And they had set aside $1.8 billion, 3 times the $600 million that it settled for. So the subjective belief of the infringer was that it was worth 3 times what it actually settled for. The objective belief of the market is 2 times what it actually settled for. And you know what the patentee wanted early in the case? I don't know for sure. I only know from the public record. But the public record suggests it was somewhere around $3, $4, $5, or $6 million. 1/100th of what the case settled for. That sounds to me not like the troll lurking under the bridge trying to surprise at the innocent passerby. That sounds like the Heisman Trophy. I'd like to negotiate with you. Talk to the hand, man. That doesn't sound like hold up. That sounds like hold out. That sounds like somebody showing up to a negotiation by not showing up. And it certainly doesn't sound like lack of notice. Sounds like everybody knew exactly what was going on. And in fact, the infringer got a very good deal by playing the game out for many years and beat the market estimate by 2 and beat his own estimate by 3, but happened to pay 100 times what the patentee would have given him the deal for early in the case. He bought an option. So if we're really going to think about options, we should take seriously that every economist believes that scientifically options have positive value. So when we think about patent valuation, we should think about 2 options that have been absent from most of the conversations today. 1, the option for the patentee to say no, and 2, the option for the patentee to say yes exclusively to someone other than the particular infringer in the case. And so maybe if we want to do a scientific assessment, evaluation, we should at least include those 2 options and the pricing of those options in those models.
Okay. Matt, and then John, and then we will go to the audience.
Well, I actually wanted to talk about the clearance issue, so maybe, because I really don't have any thoughts on whether RIM deserved a better deal or a worse deal. The problem with clearances, which we should think about, at least in the software space, which I'm quite familiar with, there are not simply hundreds of thousands of patents, which there are. The language of the claims is frequently non-standard, which makes it difficult to search. And there are not simply parties out there that you need to find, even if you found them all, which as a practical matter, I mean, there was one estimate that Tim Lee, who's at the Washington Post, did. I don't know if it's true, I don't know if he's correct, but that it would actually take more lawyers than there are in the US to be able to review all of the software patents that are out there. And I may be overstating it, but the fact is it still would require an inordinate amount of resources simply to clear one product effectively. But there's another problem, which is that even if you found all of those patents and found all of those parties, many of them actually don't care. You know, we think about everyone who has a patent is not necessarily looking to sue on that patent. They may have gotten it and forgotten about it. There are plenty of patents where people simply got it issued, they were working on something, they wanted it, and then they didn't do anything. So now you end up with a huge amount of dead weight loss, where you go and negotiate with people who actually weren't going to bother you in the first place. So you can't even identify, not only can you not identify who you're threatened by, but even when you find risk, you really can't assess the risk at all. Do I need to negotiate with this party at all, where they were, you know, maybe now they will, now that I've let them know that I think I infringed their patent. There's a real notice problem in the sense, and in this case what I mean by notice is that the patent system is not serving the proper notice function. I mean, any particular patent we can debate whether it gave adequate notice of what it covers, but as a practical matter, certainly in the software area, in e-commerce, in tech, IT, whatever field you want to call it, it is nearly impossible to figure out where you stand. You almost certainly infringe something somewhere, but who you might have to pay to, if anybody, it's almost impossible to figure out. So that notice function is really not being served adequately.
John.
I'll just add one point on this. I mean, I think it goes back to, again, a point made by Michael earlier today, although he suggested this wasn't a likely way to address the problem. I do think when we talk about the numerosity problem, I think to the extent we really believe that is a problem, it does raise the question of whether the standards for patenting in this space need to be higher. So you have fewer patents. And I recall when I was at an FTC hearing, Bob Armitage, who I believe was general counsel for Eli Lilly, he sort of blamed the problem in the software IT space on the companies there, saying, well, you have companies like Microsoft, IBM that have made their model getting 3,000 patents a year. You helped create and foster a system where you're having the huge number of patents we have here. He felt that the pharmaceuticals companies had done a better job of helping to police their space, so you didn't end up with the same sort of numerosity problem there. I tend to think there are differences in technology which make this comparison not necessarily the best one, but I just throw it out there as a suggestion that maybe the companies involved need to think about how they can help police the system and get the patent office to help prevent the large numbers of patents that they then claim to find impossible to clear.
Great, thank you. So let's go to the audience and get some questions. Yes, back there.
I just had a comment. Mark, I agree that with respect to SDOs and FRAN commitments, that it's a commitment to the SDO and it is a contract. However, interpretation of that contract will have to go back to quote the legislative history of the SDO. So you can't presume that simply because you've made a RAN commitment that you've given up your right to an injunction. You really have to look at the SDO policy and the intent of the members. And in fact, I'm only aware of one SDO to date that has considered that issue, and that was Etsy in the 90s. And they actually pulled no injunction language from that SDO policy because companies were threatening to leave. So you cannot presume that simply because you make a FRAN commitment that you've given up your rights to enforce certain patents in standard-setting organizations. Now, of course, if the companies want to make that a part of the SDO policy, they can, but I think that some people have been making that statement for litigation purposes and try to retroactively change the policy to suit their needs. So you have to be very careful with that. Look at the policy, find out what the parties intended, and don't presume that that's what they did. The other thing is that with respect to the ITC and district court, it's my understanding that litigants usually file in both, and there's a legitimate purpose for both. The exclusionary order to keep infringing products from coming into the country. Can you imagine a scenario where you have a foreign company that simply raises SEPs in the case, and all of a sudden you don't have the right to exclude simply because they raise an SEP in the case, and you won't, the determination on an SEP isn't made until later. So that company continue to infringe and actually have a competitive advantage over other companies that have entered into licensing. So I think there is a legitimate role for both, and I think we have to keep the dialogue open, and I believe that district courts and the ITC have remedies that are that can deal with the issues, and they're capable of handling them.
So I think it's certainly right to say that we ought to look at what the SDOs actually do on a case-by-case basis. And so one of the issues that came up in one of these early disputes involving Rambus was they didn't have a licensing obligation at all. They had only a disclosure obligation. That said, I think it's also right, as you suggest, that most of the organizations have not said anything one way or the other, so we're left to interpret from silence, which is always a little difficult, and you and I might disagree on what that interpretation might mean. But to me, if the answer is, if the organization were to say, you must license all comers, all users of the standard on reasonable and non-discriminatory terms, but the patentee is free to get an injunction that prevents you from practicing at all, I'm not sure what that reasonable and non-discriminatory term obligation actually means, right? It seems to me that it's gotta mean at a minimum that if someone's willing to pay me what either we can agree on or what a court sets as the reasonable royalty, I've got to accept that in exchange for giving up a right to injunctive relief. Now that doesn't mean that I could never get an injunction. I think there are cases, for instance, in the smartphone world, in which Apple says, Motorola, you've committed to license on reasonable and non-discriminatory terms, so you can't seek an injunction. And court, I want you to tell us what a reasonable and non-discriminatory term is. And the court says, okay, I just want to make clear that I'm resolving a contract dispute, and that you, Apple, are going to pay what I determine to be a reasonable royalty. And Apple says, oh no, I'm not going to pay this unless it turns out to be the royalty that I like. And at that point, it seems to me, you don't have a willing licensee. Apple's not saying, I'm actually willing to pay the reasonable royalty, and I ought to be able to go after them for injunctive relief. So I think and the ITC, I think, fits in exactly the same way. That is, until I know whether the patent is essential, until I know whether someone is willing to license on reasonable and non-discriminatory terms, I've got the possibility in either of those cases of seeking injunctive relief in court or an exclusion order in the ITC. But I don't think if people are willing to pay the reasonable royalty, that we can say, you know what, I've changed my mind, I don't want to license you on a reasonable royalty, I want an injunction against you instead.
Does anyone else want to weigh in?
Yeah, I do. I think that the idea is not, I think that what Monica was talking about is not so much the changing of the mind. I would give you a reasonable royalty and you've said yes, but you know what, I'd rather just enjoin you. And the problem is really the reverse holdup one, which is a company refusing to even negotiate or rejecting offers. The problem that the Apple-Samsung case, actually, the problem that I had with, I have to disagree with Mark on the USTR's decision. What the ITC actually found was that Apple hadn't made its case, that Apple hadn't actually established that the patent was standard essential and hadn't established some of the key points, and therefore there was no reason to not issue an exclusion order. And the USTR basically came in and acted like an appeals court and said, well, they got it wrong. And that's really not what the presidential review was supposed to be for. But anyway, if we're going to have the ITC issuing exclusion orders, then it becomes difficult to say, well, certain patents are okay, certain patents aren't. But I mean, the ITC certainly did the best that it could with attempting to figure out, is there a FRAND obligation here? Are these patents actually standard essential? I guess I just wanted to say those things to get to disagree with Mark for once.
Okay, Scott, did you want to? Okay, let's get another question. Yes.
I want to go back to the notice of appearance and something Mark said about willful infringement or copying. And I think that for big companies, I think it's a little disingenuous to say that they only copy patents. You said, oh, it takes 4 years to run. But, do we really think that when Samsung put in swipe open, that they weren't copying Apple's patent? That was already out, and Apple
Well,
that's
I mean, if I can just
Go ahead.
respond to that last point. So, because I mean, I've done clearance searches too. There is a scope within certainly you could clear. For example, if I have a product, I could clear the product itself or some major portion of it. But as we know, there are many patents that will cover pieces of it. There are patents that might cover some concept that you're using and may not even realize that you're using. It's really, I guess I would stand by my claim that it's not possible to completely clear. You can clear within a space. As to whether big companies do or not, and Google did or not, I can't speak to because I don't know. But
But John, this is why I think the system itself is so pernicious, and it's not that one side is a good guy and one side is a bad guy. The problem is the system. So let me first off say, Scott pointed to several examples of here are some willful infringers, right? Apple versus Samsung. I absolutely agree, right? If it looks like you copied the product, yeah. Then I got no problem with saying you got to go find out if there's a patent out there, and if you don't take a license, then we're going to come down on you, and that's why we have willful infringement damages, and we should. But what's important to note is, right, these are individual cases, and the evidence that Chris Katropia and I come up with suggests it is a tiny fragment of the cases that are being asserted, and even of the cases that are going to judgment. Right, the cases that are being asserted and settled are overwhelmingly not cases in which I knew about your product. First off, they're overwhelmingly, as we saw this morning, they're not even cases in which there was a product out there, right, at all, right? They're non-practicing entity cases. And they're not cases in which there's any reason to think that the defendant knew about the existence of the product. Now, is that because the defendant didn't do a good search? I think we ought to have a world in which you could do some substantial searching, but the problem is we don't have that world right now, and we've kind of structured our world in such a way that we make it, it's perverse, right? So lawyers tell their engineers and software companies, don't look at patents. Right? Because if you look at patents, maybe then you're going to get me in trouble. That's not a good world to have. But the reason we have it, I think, is because we've got so many patents of such uncertain scope, and I have no idea whether or not this person is ever going to show up, that if I do decide to pay the official, the Lee and Mulligan paper suggested that it would, if you just spent 10 minutes of lawyer time per patent, if each software company hired them, we'd need 2 million software lawyers working full time to do the clearance search. Right? We need a world in which that's not the right number, and even by an order of magnitude. You could do that maybe if you got rid of, if you required copying, right? If you got an independent invention defense. Maybe you could do it if we narrowed the scope of the overbroad claims, so that I couldn't just sort of describe in vague terms what my patents were. We could do it, I suppose, if we wiped out 95% of the IT patents. I'm not sure any of those is a great solution. So I don't know that I have a great answer to getting out of the conundrum, but I think it is a conundrum that's not caused by either plaintiffs or defendants being bad actors. It's caused by the fact that there's so much information out there that we just can't process it.
I do feel like I should say I'm not an apologist for people who don't do searches. As I said, I've had clients, you should be doing a good faith search. My point is that you're not likely to really get the result that you need, which is true clearance.
Okay, let's take another question. Yes.
Can I follow it up with get some advice about clearance in a real world situation that doesn't happen infrequently in my practice? I had a small client who can barely afford to pay me to try to get a patent. They did some prior art searching on their own for patentability and found a patent, and they said, I was looking at the claims. I said, you don't need to look at the claims for patentability. And they said, I looked at the claims and it reads right on what we're doing, but it also reads right on technology that I know existed for the last 20 years. What should I do? I said, well, you should probably get me to write you an invalidity opinion. He said, well, I can't afford to do that. That's a real world situation that happens not infrequently.
I've had that happen, and I don't really know the best answer. It's, what often ends up happening is they'll just go ahead and take the risk. And this is something that happens with, the copying cases. For all that it may be that one copied from another, maybe that they both copied from the same source originally. Certainly that's how we end up with the Windows and the Mac interfaces. Xerox did it first anyway. But that's just a really tough call, and it's something that happens with startups all the time. Just doing any clearance at all is often money that they don't have, and they typically just try and wait.
And what would you logically say to them? You'd say, as you said, don't read the claims, right? You don't have to do it. Maybe the lesson they take from this, if they have to go pay their opinion, got to pay a lawyer for an opinion counsel, is I better not look at a patent next time, and thus the cycle perpetuates itself. Right?
Yes.
My own belief is I don't think it's that hard to do the clearance searches. We do them all the time. I will tell you, when we used to do, I used to patenting my old days, and what I have my guys do now, generally when a software engineer tells me they invented something, other stuff, we immediately check, because I do believe a lot of them are reading the patents. I mean, it's amazing how I can find a patent, in a few hours. Gee, you never knew about this one. Because a lot of them are under a lot of pressure to patent. And where else are they going to find this stuff? But I don't think it's that difficult to really do it. And I used to be in-house. I don't think it's that hard to really do a decent search. I know a lot of my colleagues, when I was in-house, would not do those searches.
On the question of whether software engineers are developing their code by reading patents, I think if that's right, God help us all.
I have to say,
the code. No,
I was a software engineer. Yeah, I was at IBM for a few years. I can never.
Let's not debate that.
Yeah, they don't do it. But anyway,
We got another question.
We have one more question. Yes, Michael.
Okay, so still on this clearance thing, let's say I agree that, it's just too much trouble to do a good faith search. Mulligan and Lee are right. I don't think so, but let's say they are. Then the least cost way to figure out which patents are relevant are to wait till you get the demands, which is what happens now. So the question is, what do we do about that? It seems like there are two ways you can deal with that. One is, when you get the demand, you deal with it as if it were a clearance issue. The other is to say, let's get rid of patents in a certain area because there are too many of them. We don't like getting demands. One of the concerns I have with the patent reform is we're getting demands. People are telling us they have patents. We didn't know about the patents. If we accept that clearance is impossible because it's too costly, we should accept as part of the system that we will never know about all the patents. And so why should we get rid of them all simply because we're doing the most efficient thing we can to figure out what's relevant?
Well, I mean, what's striking to me about this discussion, and so many of them in context, is there are some tensions here. There are tensions on the one hand. Do you really, as Michael has just pointed out, do you really want to know whether you've got to deal with somebody? Well, if you do, because they write you a letter, or because they sue you, is that such a bad thing? I mean, is it so bad that your client will eventually find themselves the recipient of a letter or a lawsuit? Why not write back a letter that says, thank you so much for telling me about your patent. I've enjoyed reading it. It turns out, as you mentioned, that we happen to, and as you mentioned, we happen to have this piece of prior art that happens to be exactly what we're doing and predates your patent. Now, if you want to write us back, we look forward to it. But we're now creating federal rules of civil procedure, federal rules of evidence stuff, and we're now communicating and in writing. What's so wrong with that? Why is that so expensive? Now, I guess these things turn out to be somewhat hard, and I guess we all have to roll up sleeves a little bit, but, I don't know. Judge Posner is throwing out expert testimony and telling us that absent scientific evidence of true value, we can't even move forward to adjudicate the question. And so, there's this tension. We want information or we want no information. There's another tension. We want information, we want it now, but we don't want to pay for it and we don't want to wait. Well, guess what? I mean, if you got, Going and finding the prior art takes time. Going and finding evidence about true value takes time. And I assure you, the other side of the V is going to have a radically different perspective than yours. And so it's going to take time times 2 and times 3, because the person in the middle, the agency or the court, is going to have to reach her own view about the 2 views before. So I think as we have these conversations, we should keep track of these very contrasting goals. If we're really serious about them all, maybe we actually end up in a system that's pretty close to the one we had 10 years ago. But I don't know that we end up in this system, and I don't know how it gets us to further those goals by going further in the direction we're going.
Michael, it may be that that's the best we can do, right? That the answer is you wait until you get the threat letter and you deal with it then. That's the way we've kind of muddled through the system now. I guess I would say 2 things. It's obviously not ideal, but it might be the best we can do. I would say 2 things about that system, right? One is, if that's right, then maybe to bring this back to what the panel was originally supposed to be about, that has implications for whether or not we should be granting injunctive relief, right? Because we're now doing everything ex post. We're now determining what the patents are only after the people have made the investments in producing the products in the first place. And so an injunction has a much more substantial risk of holdup in that circumstance. So I think that's one implication. The second implication goes back to something Mike Moyer said this morning, which I think I just find quite distressing from the software patent perspective, right? Which is, what we'd like to have patents for is to encourage not just invention, but technology transfer. And we see virtually none of that in the software patent world, and part of it is this reason that we're sort of, rather than you've got an idea and I want to buy it from you ex ante, when we wait ex post until I independently invent the same idea and then you discover it and you send me a threat letter, we might or might not be transferring wealth between people for good or bad purposes, but we're not getting the technology transfer that I think would have been the point of the system in the first place.
Okay, I'm told we have time for one more quick question, so Mike.
That's a foul.
Yeah, I think we got to rule that one out of bounds.
Unless you route it through the panel, it's disqualified.
Use the mic.
We're hiring people to patent rather than to innovate. And the system is such a mess that I think that is becoming a very serious problem.
Okay. Mark or Matt?
Well, I actually was going to say that I think that's right. And this is what happens when you take the technology transfer piece out of patents, which is just the nature of an incredible volume. We end up with essentially patent anonymity, right? If you only have a very small number of patents to search, then each one can become more significant. But in the same way that if you move from a small town to New York City, you no longer know everybody, and in fact, you no longer even have the ability to really get to know anybody except maybe in your little neighborhood. This enormous volume makes it almost impossible to really even gather knowledge, and patents no longer serve that function. So we do everything ex post, and people begin to focus on patents as assets and things that can be monetized, and then the incentive is to make more patents.
Anyone else on the panel want to comment?
Yeah, I mean, I just kind of don't. I'm afraid, I'm embarrassed. I don't understand the question. I mean, are you suggesting that the idea of creating an organization and a field of endeavor called law schools and the profession of law is, something that we should not do? Or are you saying that having done it, we should not use it? Or are you saying that I just kind of don't get what you're like. I don't think he's saying that his clients are hiring people they would otherwise have hired to do software design and are asking them instead, please don't help the company's bottom line by solving problems for its customers. Please instead, I'd like you to get these beautiful eagles that you can put on the wall and Yeah, but I don't know how you get that inference from his question or his comment. I mean,
let me try to sort of articulate
well,
what's
just
going
one
on.
second.
We have 30 more
I
seconds,
think
so
that if you make patents pretty weak, you will further the very frustration you are complaining about. And if you make patents more robust, you will mitigate the very problem you're expressing. And so it sounds like a more robust system.
Mark, 30
We have
seconds.
15 of the 30 seconds, right?
Go for
Here's what I think. Here's what I hear, right? Which is the story in favor of the patent troll is the intermediary story, right? We are serving as arbitrageurs, right, between the inventor and the company. The question is, what are we arbitraging? What are we selling, right? In a good world, what we're selling is actual technology and knowledge that moves from one place to another. And I think Mike's worry is we've moved beyond that world, and the only thing we are selling are the legal rights to exclude, divorced from the technology that we would hope to have transferred in the first instance. And that, if true, is worrisome.
all right, on that note, let's call this panel to a close. Thank you very much.
Thanks, guys.